Good morning, everyone, and welcome to the Metcalfe and Curran's webinar on the new regulations on beneficial ownership of trusts. My name is Burke, and I'm a solicitor on the Charities team here at Metcalfe and Curran. I'm joined this morning by my colleague Nick Metcalfe from our Governance and Compliance Department. Nick will speak generally on the trust regulations, and I will first speak specifically on matters concerning charities and not-for-profits. We will have time at the end of this webinar for questions, so if you have any questions, please send them on the Q&A function as we go along, and we will try to deal with those questions at the end. I expect the webinar to take around 30 minutes this morning. And I'd ask you all to note that this webinar is being recorded. So just to introduce our topic, you're all no doubt aware of the trust regulations since you're here with us today. The trust regulations have been introduced in Ireland this year on foot of a European directive dealing with anti-money laundering, and their aim is to promote transparency in legal structures. Some of you may already be familiar with the beneficial ownership regulations applicable to companies, and you may have registered your company on the central register at the registrar of companies. The trust regulations were aimed at legal arrangements beyond companies or everything else, and so have a broad scope and have captured all sorts of entities, including charities. I would also point out that there is no de minimis or minimum value of trust to which the regulations apply. All relevant trusts are caught by the regulations, regardless of size. It is often difficult to reconcile beneficial ownership with charities, as charity trustees and members do not own the charity and do not benefit from it. Charities may have a class of beneficiaries, but no individuals can be identified as beneficiaries as such. However, the extremely wide scope of the regulations means that they apply to charities and not-for-profits. Some attempt has been made by the lawmakers to recognise that charities come under the trust regulations, but need to be considered differently. And we will see this later around charitable trusts. However, there are many issues arising from the trust regulations which are not a good fit with charities, and unfortunately there is a lack of clarity around the regulations. The Revenue Commissioners have established working groups with practitioners, including a charities group, and have been endeavouring to deal with and provide clarification on some practical issues. We have benefited from some of those clarifications, and I will highlight those for you this morning. Now to examine what this means for charities and not-for-profits. On this slide, I've set out the different types of charity according to the Charity Regulator's 2020 report. And you will see that most charities are incorporated, that is, they are companies, usually a company limited by guarantee. Only 621 charities are in the form of a charitable trust. The remainder are a mix of unincorporated associations, and religious congregations often fall into that category, and other legal structures. Boards of management, schools take up a large proportion of registered charities. As I said in the introduction, clearly there is some difficulty reconciling the concept of beneficial ownership with charities, but nevertheless, the trust regulations apply to charities with relevant trusts. So in short, what are the trust regulations? And as this slide summarises, the trust regulations apply to all express trusts. These are trusts established by deed or declaration in writing, and whose trustees are resident in Ireland, or the trust is administered in Ireland. So what kind of charities or not-for-profits will the trust regulations apply to? And turning now, we will look at charitable trusts. What are they? So charitable trusts have a particular definition under the Charities Act and are designated at the Charities Regulator as trusts. And you can check this, for example, on the Charity Regulator's website. A charitable trust must be established under a deed of trust for a charitable purpose only, that requires the trustees of the trust to apply all of the property of the trust in furtherance of the charitable purpose. For charitable trusts, the new trust regulations clearly apply, and both an internal register of beneficial owners and a filing on the central register of the Revenue Commissioners is required. I will discuss what needs to go onto that register for charitable trusts in a few minutes. If your charity is established as a company, and that's normally a company limited by guarantee or a CLG, then Revenue has clarified that an incorporated charity does not need to register on the Central Register of Trusts. And I've included reference on the last slide of my presentation to where you can find Revenue guidance, or its FAQs, as it calls them, on the trust regulations. And this is being updated on an ongoing basis as more clarification emerges. However, I must stress that a charitable company still needs to consider if there is anything in its memorandum or articles of association, its constitution, which amounts to an express trust, or if any other relevant trust documents are in place. An express trust is a particular thing in law that's identified by three characteristics, or the three certainties as we call them. Certainty on the subject matter, certainty on the object of the trust, and the intention to create the trust. And in addition, for the purposes of beneficial ownership rules, the express trust must be written in deed or declaration in writing. Therefore, we recommend that you seek legal advice to confirm whether an express trust is contained in your charity's constitution or other documents. I will speak about bare trust companies or property holding companies separately in a moment. And for companies, which are charities, in any event, please bear in mind that companies are already subject to the beneficial ownership of Corporate Entities Regulations 2019. And this obliges companies to keep a register of beneficial owners and file on the Central Register of Beneficial Ownership maintained by the Registrar of Companies, quite separate from the trust regulations we're talking about today. For other types of charities, including religious congregations, the position is less clear. And these charities should seek legal advice on their obligations under the trust regulations, as if their charity is established by deed or other declaration in writing, and that written document contains an express trust, then there is an obligation to comply with the trust regulations and to register on the Central Trust Register. The question, for example, whether a canonical constitution amounts to a declaration in writing or contains an express trust may be specific to that congregation. And so we recommend that those charities seek bespoke legal advice on their obligations. Where this is relevant also is regarding arrangements in place for the charity's investments, property, and other assets. If your charity, regardless of its legal form, has put in place a written document pursuant to which any of the charitable assets are held on trust by third parties, including, for example, in the names of individual people connected with the charity, those written arrangements must be looked at to determine if the written document contains an express trust. This would then result in an obligation to comply with the trust regulations and to register on the Central Trust Register. Examples here could include where an individual holds shares, for example, in Bank of Ireland, for example, and they're held on trust for the charity, and you might see this through a legacy or a bequest. And if there's a background document or declaration of trust around that, then that's important. Or someone might hold the charity's property in their personal name, but on trust for the charity. Where your charity has established a property holding company or a bare trust company, this company must also consider its obligations under the trust regulations. And this can be common, for example, religious congregations. If there is a trust deed or other declaration in writing establishing the trust, or if the bare trust company is operating under an express trust, it may have additional obligations under the trust regulations. So where the trust regulations do apply, it means that the trustees must take reasonable steps to obtain and hold adequate, accurate and current information in respect of the trust's beneficial owners. As I mentioned before, there has been some recognition that the trust regulations do not fit well with the concept of charities, and so different arrangements are in place for charities to identify beneficial owners. So instead of pinning down who might benefit from the charity, for charitable trusts, the beneficial owners will mean trustees, any committee or governing body managing the trust, and any other person with control. Information required in the register then includes the name, address, date of birth, and nationality, as well as PPS number. And the register must also include a statement of the nature and extent of the interest held, or the nature and extent of control exercised. This can be readily ascertained from a review of the trust deed. And indeed, Revenue have given some examples of what this might be in its FAQs, such as the power to appoint trustees, the power to dispose of or invest in trust property, and so on. However, note that this guidance on beneficial owners for charitable trusts is limited to charitable trusts only, as defined in the Charities Act, and not, for example, applicable to bare trust companies. Furthermore, there's nothing in the trust regulations that outlines how trustees, which are companies as opposed to individuals, and this applies to bare trust companies, so it isn't clear how those companies fill in the register. And there are limits on the online revenue system, the online system with the revenue commissioners, in accepting information onto the register. So for example, if a bare trust company wanted to register, it is not clear how it should do this in practice at the moment. So we're in a position where compliance with these new regulations commences from this week. But the situation is far from clear on every issue. Also, with the criminal sanctions for breach of the trust regulations, and Nick will go into that in a bit more detail, it is obviously something that all trustees need to pay attention to. For charities that are charitable trusts, the position is clear, and they should create an internal register and file on the central revenue register as soon as possible. And I would say that whilst there's not a register of trusts in Ireland, for companies, for example, the Register of Companies holds a list of all companies. A list of charitable trusts can be found easily at the charities regulator, should anyone wish to follow up or check on compliance. We at Mason Hayes have access to the online revenue system and can assist you with filing your trust details on the central register. We can also assist you to create an internal register of beneficial ownership for your trust. For other charities, you should seek legal advice on your documentation to confirm whether there is an express trust and whether or how the trust regulations apply to you. And again, we at Mason Hayes would be happy to assist you with that. For more information, I've included on this slide the link to our recent newsletter on this topic, and also a reference to where you can find the revenue FAQs for more information. So I hope that was a useful summary of the position to date on the trust regulations, particularly as they relate to charities. And now I'll hand you over to Nick, who will give you a more detailed overview of the trust regulations themselves.
Thank you very much, Una. As Una has, and good morning, everybody, and thank you for attending today. As Una has noted, the regulations are very specific with regard to the requirements of charitable trusts. But there are other circumstances where charities will be involved in trust circumstances which are not within that narrow definition. And for that reason, and just as a general recap of where we are with the regulations generally, I will spend a few minutes now just explaining how they operate generally and not just specifically with regard to charitable trusts. So as a general term, and Una has touched on all of this, the regulations have been in force since April of this year. And the main thing that they did do to build on earlier regulations was to establish the central register, which is operated by the Revenue and is open for filing under ROS. And again, just to reiterate, because it is only 2 days away, the deadline for filing for trusts, for all relevant trusts, which were in existence as at the 24th of April, is the 23rd of October. For any trust which has been established since April, the deadline and subsequently, the deadline for filing is 6 months from the date of establishment. And the regulations, again, as Una touched on, are there to establish a database, and not just in Ireland, but these will, similar types of legislation will be enacted across the EU to establish a database across the EU to assist the combat of money laundering and terrorist financing, to try to establish a database where the various states can try to find out who owns or who is beneficially entitled or who controls trusts. As Una has said, there are already registers for companies. There are also registers for ICABs and similar financial institutions, and this is essentially to sweep up the rest. Next slide, please, Eva. There were, before these current regulations, there were some regulations in force, the 2019 trust regulations, which came into force in January of that year, and they obliged only trustees of relevant trusts to obtain and hold information on their beneficial ownership, and to keep that information on an internal register. So just to go on to the current regulations, there are two important definitions we need to look at. One is what are called relevant trusts, the trusts to which the regulations apply, and the second one is who the beneficial owners for the purpose of the regulations are. And the definition of relevant and definition of both of those terms has changed since the 2019 regulations. Relevant trust is now taken from the definition is now taken from the Criminal Justice Money Laundering and Terrorist Financing Act 2010, as that act has been amended. And it is, again, as Una has mentioned, an express trust which must be established in writing, unless it is an excluded arrangement. And excluded arrangements include certain types of occupational pension scheme, certain types of approved retirement funds, certain types of employee share schemes, and unit trusts. And unit trusts are a type of financial vehicle which are already caught by other types of regulation. And if you are a trustee of a trust which you think falls into any of the other categories, it is important to understand from that act exactly the statutory framework that must exist around the relevant arrangement. So in addition to being an express trust established under a deed or other document in writing, the regulations also require the trust to have certain geographical restrictions in order to fall within the scope of the regulations. And broadly speaking, the relevant trust must have trustees who are resident in Ireland or which is otherwise administered in Ireland. And the exception to that is where neither the trustees are resident in the EU or the trust is not administered in the EU, but the trustees acting in that capacity as trustee either enter into a business relationship in Ireland or who acquire land or real property in Ireland in the name of the trust. And a business relationship is exactly what you'd expect it to be, but it must be done by the trustee acting as trustee on behalf of the trust. The second definition that is worth looking at is that of beneficial owner. So if you are a trustee of a relevant trust, what do you need to establish? Well, again, the latest regulations have changed the definitions as they appeared in the earlier set of regulations and as they appear in the 4th Anti-Money Laundering Directive itself. And Una touched on this, but it's worth noting that the beneficial owner for the purpose of the regulations is any individual who has a vested interest in the relevant trust property, so a beneficiary as we understand them, where there are no individuals who can be identified by name, then a class of individuals in whose interest the trust is set up, any other individual who otherwise controls the trust, and then the settlor, which is the person who establishes the trust effectively, the trustee or the protector. And the protector is more of a European concept and not really applicable to Irish law. And for the purposes of that definition, control over a trust is what you would expect it to be. It is if some person who is not otherwise in the categories can do any of the things I've listed on this slide, and they're fairly self-explanatory. As Una mentioned, charitable trusts are a special case under the regulations, and there are two other categories of special case that I'll mention here for completeness. One is approved sports clubs, and by approved I mean those that which are established for promoting amateur games or sports under the Taxes Consolidation Act. And similarly to charitable trusts, the beneficial owners that the trustees have to obtain details of are the trustees themselves, or the committee or other governing body, or if there is an individual who doesn't fit that description who otherwise controls the club, that person. And the other category is where a trust is established by a deceased person's estate. And in those circumstances, the beneficial owner for the purposes of these regulations is only the executor or executors or the administrator or administrators of that estate. Una mentioned these, so I won't go into them in much more detail. This is the information which trustees are required to obtain about their beneficial owners. The one thing I will say is that there is a requirement to obtain the beneficial owner's PPS number, and if the beneficial owner does not have one, for instance, because they're not resident in Ireland, then there is a requirement on the trustee to obtain another type of identifying number, and the regulations list either a tax reference number in the beneficial owner's own jurisdiction, or a passport number, or other kind of national identity number. And the trustees are also obliged to obtain a copy of the documentation which has that number on it as proof. Having said that, the regulations then go on to establish two other circumstances where the trustees have additional duties. And those are where the beneficiary, and it's important here that it's beneficiary and not beneficial owner, but the beneficiary of the trust is a legal entity. So that would include a company, for instance. And there are two distinct circumstances within that. So if the trustees of a relevant trust find that and this of course doesn't apply to charitable trusts because they don't need to go into the beneficiaries, but for completeness, where the trustees establish that a beneficiary is an Irish company, and that Irish company has made filings on the Irish Register of Beneficial Ownership of Companies, the trustees' obligations are just to go to that register, identify the beneficiary, then record on their register the nature and extent of the interest or control of that company, and any filing number assigned. Where the legal entity does not, has not made filings on an EU register, so let's just say the beneficiary in question is a company incorporated in England and Wales, then the trustees' obligations are a bit more serious, and they have to go and find the individuals who are constituted through that legal entity. That's not really a term of art at company law, but we can extrapolate that it's the beneficial owners or people who otherwise control the company. But the problem is with that, with the beneficial ownership of companies legislation, there is a cutoff point. So if a person owns less than 25% of a company, they're not considered a beneficial owner. There doesn't seem to be the equivalent level of de minimis, of a minimum ownership here. So it's likely from a strict reading of the regulations that a trustee would have to go and find details of every single member of a non-EU company, which was a beneficiary of the trust, which, depending on the number of members, could be quite an undertaking. I'll just recap that on this slide, that there's a slight grey area of what, and Una touched on this as well, of what happens where the trustees themselves are legal entities. The regulations don't elaborate in the same way as they do where the beneficiaries are legal entities. And from what we understand of the filings attempts to be made to date, there isn't really a mechanism, as we understand it, for filing details of a corporate trustee. So we've established that the trustees of a relevant trust have to find out who their beneficial owners are, or the trust's beneficial owners are, and the regulations contain very detailed notice provisions under which the trustees are obliged to send notice either to the people they suspect have been beneficial owners or to people who they think might know who they are. And there are penalties for non-compliance with those notices by anyone who receives them. There are also obligations on people who themselves know or suspect that they are the beneficial owners of a trust to write to the trustees and say, look, we are a beneficial owner. Do you have our details? Are we on the register? The internal register is open to inspection by the arms of the state listed on this slide, who have responsibility for enforcing anti-money laundering and counter-terrorist financing. And those bodies can share the information they get from the register with their equivalents in other member states. One of those classes is what's called a competent authority, and those are bodies who govern what the legislation calls designated persons. And designated persons are those types of people who have to carry out customer due diligence to ascertain the identity of their clients. People like lawyers, banks, accountants, and the like. And so it follows competent authorities who are entitled to inspect the internal registers are people like the Central Bank of Ireland, the Law Society, and so on. And speaking of designated persons, where a trustee of a relevant trust enters into an occasional transaction or a business relationship with a designated person, where effectively, let's use an example, the trustee of a trust engages a law firm on behalf of the trust, acting in their capacity as trustee, then the trustee is obliged to tell the designated person they are a trustee and provide information on the beneficial ownership of that trust that they have from their own internal register to assist the designated person in establishing the identity of their client. So as I noted, as indeed Una has also noted, the regulations establish the central register run by the revenue, and the obligation extend to the trustees now to file details of the information on the beneficial ownership they have on their internal registers. And there is an ongoing obligation, as you would expect, for trustees to keep that information on the central register up to date as things change. The same people who have access to the internal register also have access to the central register. Those are, as I've said, the arms of the state who have an interest in this kind of thing, and the competent authorities. And there are safeguards in place. So if any of those bodies wishes to look at the information on the central register, the request must come from an individual of a certain position or rank, and they themselves must be authorized by a person of a higher position or rank. There is also what the regulations term restricted right of access, and that is access by certain people to some of the information that's on the central register, and that is the beneficial owner's name, the beneficial owner's country of residence, rather than the full residential address, which will be a boon for certain, for most beneficial owners, I would have thought. The nationality of the beneficial owner, and the month and year of date rather than the full date of birth. And designated persons have that restricted right of access, but only where they're entering into a business relationship with the trustee in the capacity as trustee. And other than that, to restrict any access, and restricted or otherwise, is only open to other people in very limited circumstances. So by way of contrast, the central register of beneficial ownership of companies is open to you and me for any reason we want if we pay a fee. That isn't the case for the register of trusts. And any person other than those we've mentioned must demonstrate to the registrar that they have a legitimate interest in inspecting the register. And that legitimate interest is, largely speaking, with one exception I'll come on to on the next slide, that the applicant is basically involved in combating money laundering or terrorist financing, and they need this information as part of an ongoing investigation. So it's really limiting for this particular aspect to effectively non-Irish and non-EU, really, by extension, law enforcement agencies and the like. And the other example, which is wider, is that others may have that access to restricted information where the relevant trust holds or owns a controlling interest in a corporate or other legal entity which is incorporated outside the EU or controls that legal entity by other means. And Una mentioned before, as you would expect, there are teeth to these regulations. They're not just there for the good of anyone's health, but the state expects them to be complied with. And if people do not, there are criminal offences which apply to the trustees. I put the maximum down here. I mean, don't be too alarmed by that. The fines can range to up to €500,000. And if any person, be it a trustee or the presenter on behalf of the trustee, makes a statement to the registrar which is false in a material particular and does so knowingly or recklessly, custodial sentences can be applied. I mean, that is very much the worst case scenario, and it's also consistent, for what it's worth, with both the regulations which deal with the beneficial ownership of companies and also similar provisions in the Companies Act itself. And prosecutions are brought by either the DPP or the registrar, who can ask the DPP also to bring in prosecution. So that was really a whistle stop tour through the regulations from a general perspective, not just a purely charitable one. And I think now we'll have a look at some of the questions that you may have sent in.
Thank you, Nick, for that very helpful overview of the trust regulations. Yes, if I can turn now, there's been a few questions on the Q&A function. Thank you for those who may not have time to keep them all, but they'll try to take the recurring themes, if you like. One of the questions, I suppose quite rightly, is about the timing of the regulations and whether there's a grace period for compliance. And the simple answer to that is that we haven't had any indication from the Revenue Commissioners that there's any extension on the filing date. And in fact, only this week, our colleagues who deal with wills and probate and so on were also looking intensely at these regulations. There was some information circulated by the Law Society, a statement, if you like, from the Register and the Revenue Commissioners to say that there's no intention to extend the filing date. What we don't, on the other hand, have is any indication about the attitude to enforcement. Only by way of comparison, if it's helpful to say that under the companies beneficial ownership regulations, which have been enforced since I think November 2019, we're only now seeing enforcement measures or kind of compliance measures being stepped up there, and that's a 2-year period. That may have been COVID delays. I'm not saying take that for granted. Just by way of guide, if you like, but as things stand, the filing date for the trust regulations is the 23rd of October, and we have nothing further from the Revenue to indicate that would be extended. One of the other questions that's coming through on the Q&A is dealing with the subject of the property holding company or the bearer trustee company, and asking whether it's potentially in scope for the regulations. And I think the answer to that has to be yes, it's potentially in scope for the regulations. And just to recap, for companies, they have the beneficial ownership of company regulations to attend to, quite separately from the trust regulations we're talking about this morning. And I think the trust regulations come down to looking at the documentation, because this express trust, if it exists, has to be in writing, in a deed or a declaration of writing. So it's a question of opening documentation. Is there a trust deed? Is there a declaration in writing? Is there something in the company constitution which is tantamount to an express trust? All of that needs to be looked at. So it's a sort of a case-by-case basis and may vary depending on the particular content of documents for your charity. I think there is another question asking, kind of, I suppose, why don't we just register? What's the downside? It doesn't seem to be, this information is out there. It's on your company, if your company's register, or maybe in your charities regulation report. And I agree with that approach. But I think at the minute what we're facing is just some practical difficulties with a kind of a template system with the Revenue Commissioners, kind of computerized digital portal with information being asked for in a certain way that doesn't necessarily suit charities and so on, with the difference in beneficial owners. So it's not that I would have any willingness to comply. In fact, quite the opposite. It's more just that the information needed is unclear, and practically how to present that information is also unclear at the minute. But I would add that I understand the Revenue Commissioners are working on this, and they're working with practitioners, as I say, to provide clarifications where needed. And we would fully expect this to become clearer with these initial practical difficulties being worked through, if that's of any help.
I can step in, Una, if you like. There was a point of clarification really from something I said, but there is a question of what is this concept of protector and why doesn't that apply? Protector is, generally speaking, a person who supervises the role of the trustee. And you tend not to see them with Irish trusts because of the fiduciary duties owed by the trustees anyway, that it tends not to be something which is generally built in. I understand, and I don't have experience of this, but I understand that in certain European jurisdictions, the trust is more of a formal, almost regulated type of body, and protectors are often required by whatever law governs those. It's not that they wouldn't apply here, it's just that you don't tend to see them, because the trustees tend not to have somebody who looks over their shoulder questioning their decisions, who isn't the charities regulator or whomever.
Thank you, Nick. So I think that kind of deals with most of the types of questions that are coming through this morning. I appreciate everybody's situation is particular to them, and their documentation is particular to them and to their charity or their not-for-profit. So what I can encourage you to do, I suppose, is to take out the documentation, get in contact with your legal advisors to work through these regulations and how they apply to you. And I think for the minute, if there's any additional clarification that comes from the Revenue Commissioners, we will certainly aim to communicate that, whether it's through additional webinars or more newsletters. And as I said, we had a newsletter up in our insights section of our website last week on this topic to follow on from our previous easing on this subject back in May of this year. So if I bring this morning to a close, and thank you all for joining myself and Nick this morning for this webinar. And if anyone has any follow-up questions, please do get in touch. Thank you all.
Thank you very much.
Goodbye.